We're very grateful to everybody for undergoing yet another change of time. Here we are, and we'll rise at 4 o'clock, Lord Advocate, if that's convenient.
Thank you, my Lord. My Lords, the issue which I would wish to go to rapidly today is the central issue of this appeal, issue 4, which is ground appeal 1. Whether the act of the Lord Advocate in leading and relying upon this evidence of the interview of the appellant, Mr Cadder, amounts to a breach of Articles 60C and 6.1. The great institutional writer Baron Hume, in the introduction to his commentaries, Volume 1, the second edition at page 8, which is in your Lordship's volumes at Volume 9, tab 248. I wouldn't take you to it because it's such a short quote.
It's in your case too, isn't it?
It is in my case.
Yes.
In fact, this is another quote, my Lord.
Oh, yes. Right. So it's Volume 9.
This is an additional one, which is worthy of consideration, I would submit. He said in 1819, the whole train of proceedings in this or any other country must be taken into consideration in judging of any part. And if upon a complex view of the entire process, the prisoner appears to have had a fair and equitable trial, in which innocence runs no risk of being ensnared or surprised, it is all that a reasonable man can wish for, and all that is attainable to human wisdom. My Lords, it is my submission that Baron Hume's emphasis on respect for the free will of the accused, on fairness and the need to look at the entire proceedings, is an approach which crystallises that which is still consistent in Scots law today, and indeed as part of the jurisprudence of the European Court of Human Rights. The right to a fair trial is not a concept abruptly introduced to Scotland as a result of the commencement of the Scotland Act, or indeed, for that matter, the Human Rights Act, or from the signing of the treaty in 1953. It has been developed and indeed intricately woven into the substantive law and the rules of evidence over a very long period. The judicial discipline of determining admissibility of evidence is wholly allied to the concepts of fairness and protecting the free will of the accused, an exercise which continues to require the domestic courts to examine the issue in the context of the whole proceedings. And I would refer, my Lords, to the case of Chalmers, 1954, which is at Volume 1, tab 7, and Her Majesty's Advocate against Tong, 1952 justiciary cases, at Volume 2, tab 30, for general authority for that proposition. Baron Hume's approach to the determination of a fair trial also features, I would submit, consistently in the decisions of the European Court of Human Rights, an approach summarised in Edwards against the United Kingdom. Again, it's to be found at Volume 14, tab 94. I wouldn't intend to take my Lords to these cases, which I'm referring to for general propositions, in the interests of progress, unless I'm going to quote ad longum. And indeed is still typified in the decision of the Grand Chamber in O'Halloran and Francis against the United Kingdom, the case from 2007, European Human Rights Reports 554, which is to be found at Volume 5, tab 130. And at paragraph 53 of that case, the European Court continues this theme when the Court says at that paragraph, while the right to a fair trial under Article 6 is an unqualified right, what constitutes a fair trial cannot be the subject of a single unvarying rule, but must depend on the circumstances of a particular case.
Good. Can you give that reference again? I'm sure I picked up.
Paragraph 53, my Lord. It's to be found at Volume 10, tab 273.
Thank you.
And the citation is 2007. EHHR 544, page 544. Sorry, it's Volume 5, at tab 130. My Lord.
Sorry, tab?
130. 130, my Lord.
Where are we in your printed case?
We're... Just bear with me for one second, my Lord. We're at the introduction, my Lord. I don't think O'Halloran and Francis appears at that point in the printed case, my Lord. This is my oral submission. It's contained in the authorities.
So it's page 7.
Yes.
That's and you've got a quotation from Baron Hume in paragraph 23.
Yes. Yes, that's later on, my Lord, and I will come to that at a later stage.
Right, yeah.
My Lords, the Crown contends that, having regard to all of the relevant features of the Scottish criminal justice system, it is not per se incompatible with Article 6 for the Crown to lead evidence of a statement made by an accused person to the police while detained in terms of Section 14 of the Criminal Procedure Scotland Act 1995, notwithstanding that he did not have the opportunity to consult with a solicitor prior to making it.
I think prior to Saldus, one wouldn't have really much cause to worry about that. It's really the whole point of the case is what one makes of the reasoning in Saldus, isn't it?
Yes, my Lord. As my Lord and the Chair has observed, Saldus appears on the face of it to be a development. What I hoped to convince my Lords is that, notwithstanding what has been said about Saldus, that there is room to accommodate the opinion which their Lordships in the High Court and Maclean have come to, that conclusion. And indeed, if looking at Saldus itself, and indeed the subsequent case law, there is still a consistent pattern to the behaviour of the Court in Strasbourg, which suggests that it is not departing from that earlier approach. In the particular circumstances of this case, my Lords, it is my submission it was not incompatible for the appellant's rights under Article 6 to lead evidence at trial of his statements to the police while detained under this section and to rely on them in seeking a conviction. It is further contended that the decision of the Grand Chamber in Saldus, properly understood, does not compel a different outcome, and that the full bench in Maclean reached the right result for the right reasons, and that the same reasoning should be applied to the present case. Esto, the decision in Saldus is to be understood as holding that Article 6 requires domestic law to provide a person in police custody with an immediate right of access to a lawyer and precludes the use in evidence of statements made by him if no such access has been granted. I would ask your Lordships, exceptionally, not to apply that decision in this case.
Well, I suppose there are various approaches one might adopt. One would be, you say not to apply it, which is presumably prospective overruling. Would that be right? I mean, the assumption on which you make that point is that, in fact, Maclean was wrong, but you're saying don't apply it in this case. An alternative view might be apply it in this case, but not in others, because this appellant took the point and others haven't yet.
The proposition, my Lord, on the prospective aspect would be separate and distinct from my submission regarding the application of Section 2. What I hope to submit to your Lordships is that Section 2 can be applied, the decision can be taken into account by this court.
Oh, I see.
But that a separate convention rights jurisprudence can be applied by this court,
yes,
which is expert in and in a position to understand its application in the whole context of the Scottish criminal justice system.
So this is a Section 2 point?
Yes.
Yes, I follow.
It would be a similar approach to that which has been adopted in Horncastle. Fifthly, my Lord, if contrary to my submissions, your Lordships were to find the provisions in Section 14 and 15 incompatible with the Convention rights, I would submit that, having regard to Section 57(3) of the Scotland Act and Section 62(b) of the Human Rights Act, that it was not unlawful for the Lord Advocate or the Procurator Fiscal on the Lord Advocate's behalf to lead evidence of a statement made at interview by a detained suspect who had not had the opportunity to take legal advice. If, following Saldus, it is indeed incompatible with Article 6 for such evidence to be led, it is submitted that on that hypothesis, the provisions cannot be read down to render them compatible, and it would be for the legislature to amend the relevant provisions of the Criminal Procedure Scotland Act. It would also be for the legislature to make such other major consequential changes to the law as may be necessary to secure the United Kingdom's obligation to have in place an effective system of criminal justice in Scotland.
And when you use the expression a legislature, this is a devolved matter.
It's a devolved
So
matter,
it'll be the
although it's a
Scottish
United Kingdom statute.
Yes.
It is now a devolved matter. That would not preclude the Westminster Parliament acting on it if there was a refusal by the Scottish Parliament to legislate, however unlikely that might be. And of course, the Scottish Parliament would require to act in a manner which was compatible with the Convention rights, if that decision was one which was made. Should the court determine that Maclean does now fall to be overruled, it would be my submission, my lords, that in the wholly exceptional circumstances of this issue, that the court should address the temporal effect of any such ruling. Over the 10 years...
The court should do what?
should address
the
temporal effects of that ruling, my lord. Over the 10 years and more since the Scotland Act came into force, the Lord Advocate, successive Lord Advocates indeed, police officers, prosecutors, judges and juries have acted in good faith on the basis of the law as articulated by Parliament and as explained in Payton against Ritchie in 2000 justiciary cases at 271, refer to it for its terms at volume 2, tab 42. In the case of, I don't intend again, my lord, to take you there for that purpose at this stage. Dixon against Her Majesty's Advocate at 2001 justiciary cases at 203, which is to be found at volume 1, tab 11, and most recently in their lordships' full bench decision in Maclean. It would not, in my submissions, my lord, be consistent with the interests of justice overall for the change in law which would be effected if Maclean were now to be overruled, for it to be applied with retrospective or retroactive effect. My lords, it would be hard to overstate the significance of these issues for the Scottish criminal justice system. The potential for disruption to current prosecutions and to past convictions is enormous. 1.2 million convictions have been obtained in Scotland since May of 1999, that being the date when the Scotland Act came into operation for the purposes of the criminal justice system, the day in which the law officers moved from the United Kingdom government to the Scottish government and became subject to the various provisions of the Scotland Act. Each year, over 100,000 individuals are subject to detention under Section 15 of the Criminal Procedure Scotland Act. Not all of these will result in prosecution, certainly, but it gives an indication of the scale of its use in Scotland. Before considering the European jurisprudence and the facts of the appellant's case, my lords, with your permission, I would hope to examine the background and nature of the Section 14 provision, the domestic common law environment on admissibility in which it exists, and the various statutory common law and practical safeguards which also form and to some extent control the way in which it operates and is given effect. It will be my submission that when this fuller picture, that is, the whole chain of proceedings, as referred to by Hume, is examined, that there emerges a healthy ecology of checks and balances which safeguard the Article 6 rights of the appellant in a powerful and indeed in a compelling manner.
But supposing we came to the conclusion, just supposing we came to the conclusion that the High Court was wrong in Maclean, just supposing that were the case, and that the Strasbourg jurisprudence says what really was being argued, that there has to be that you have to be able to get a solicitor in order to avoid incriminating yourself without advice in advance. Would you say that in that situation, the fact that you have all these other checks and balances would mean that there was no breach in Scotland, or that there was a breach, but it didn't? There was a breach of Section 6.3c and therefore of Section 6.1, but not 1, which caused the trial as a whole to be unfair. I mean, what is it exactly? What do all these other checks and balances do? Where do they come into the picture?
It would depend, my lord, to some extent on what checks and balances come into play. Each case it is my submission would have to be determined on the basis of its own individual facts and circumstances, where these safeguards operate. But that if your lordships were to declare that the decision from Saldus was such that there would be a breach of Article 6.3, then at that stage, whether or not these safeguards in the context of the Scottish system are sufficient to prevent a further breach of Article 6.1 would be something which clearly I would support on the basis of that those safeguards are so compelling because of my primary argument that there is no breach, that thereby it would mitigate the effects of the constituent instrumental element of a breach of Article 6.3 before it got to the stage of a breach of Article 6.1.
But I mean, supposing that the argument is legal advice first, therefore, before you may incriminate yourself. Supposing that's the argument against you, as you know. Supposing that was the position. Does the fact that, for example, the thing is tape recorded so as one can see it, does that affect that argument in any way? If the opinion was that was a breach of Article 6.3, the incrimination had resulted in a breach of that right. If there had been a breach of that right as a result of the absence of the solicitor, then one of the particular safeguards in isolation is unlikely to cure that particular aspect. It would depend on what particular. But could any of the other safeguards cure that? If that's the argument against you,
it would depend on the extent of the prejudice and whether or not, again, the rights of the accused had been irretrievably prejudiced in that sense. And as my Lord Roger acknowledged yesterday, the use of the language irretrievable prejudice in the case of Saldus is not novel, it's not new. It reflects consistently the jurisprudence that has gone before, looking back to the case of Murray, where their lordships refer to irretrievable prejudice, but nonetheless were able to find in circumstances where incrimination had taken place or admissions had taken place in the absence of a solicitor, that there was nonetheless no breach of Article 6 up until the point of Saldus. And I would hope to focus on that point at a later stage. I would also hope to persuade your lordships otherwise in regard to that. If we could turn to the background to Section 14. Yesterday, my learned friend, Mr. Shedd, referred to the basis upon which the Act had been introduced in Scotland.
Do you mind if we just trace your case as you go along? Because I think it helps to give us a sort of index of where you are. As far as I can see, we're now at page 12, paragraph 23. But do correct me if I'm wrong.
Yes.
This is where...
The background to Section 14.
Yes, I mean, it says the heading is Fundamental Requirement of Fairness, Section 14. But it may be that... and this is where you are actually discussing Section 14.
Yes.
It's just that there are references there which may help us to follow where you're going.
Yes, clearly my oral submissions deviate somewhat from the written submissions, my Lord. But the Thompson Committee in 1975 looked back from the 2010 may look through that periscope somewhat quaint in terms of the terminology that it used. But at that time, the committee's purpose was to ensure that it regulated what had been taking place in Scotland informally in circumstances which were of concern, where individuals might be, because of the draconian effect of arrest in Scotland, where the absolute right to silence must be tempered by the police, where we had this loose, informal accompanying of individuals to police stations and statements being made extrajudicially and out with police stations with very little in the way of regulation and control. The whole purpose and objective of Thompson was to bring about order and to ensure a very brief period during which individuals may be questioned regarding these matters, subject to their common law rights. It was not a substitute for, nor an amendment to the common law, which remained the same.
What do you mean by subject to common law rights? What does that mean?
Essentially, any discussion or admission which took place during the course of the proposals of Thompson, and as reflected in the legislation, my Lord, namely any admission that was made under caution during that time, would not thereby be admissible. It would always be subject to the rules of admissibility and fairness. So it wasn't to overcome or in any way affect the common law which underpinned the operation of this section. It was to give structure to it was to regulate it, and thereby we focused on a short period of 6 hours which would have limitations attached to it. And in many ways, the motivation of the Thomson Committee, and some reference was made yesterday to the statement where they referred to prevent an accused standing on their rights, is not in any way dissimilar to the approach that was taken some years later in 1994 by the Westminster Parliament with the Criminal Justice and Public Order Act, introducing the adverse inference which may be taken from the silence of an accused in England and Wales, where there was the presence of a solicitor, in a sense acknowledging that there are circumstances where there may be a balance to be achieved between the individual rights of the accused and the interests of the community in the investigation and effective investigation of crime. As our Lordships and Maclean indicated in their opinion, these provisions, which were to be found originally in sections 2 and 3 of the Criminal Justice Act before they were amended, have been in place for nearly 30 years in Scotland without serious concern that the interests of suspected persons are being prejudiced. And I would compare and contrast that history with that which is experienced particularly in Turkey and some of the Central Europe and Eastern European countries, where the histories are quite different. There has been no tsunami of protest regarding sections 14 and 15 from any civil liberties lobby in Scotland. There's been no petitions to the Parliament, indeed no great momentum for change for the Scottish Parliament to adjust this over that period, and certainly there has been no one beating a path to my door regarding their concerns over the operation of this section.
So is one able to, or can one speculate as to why that should be? Is it the short period that's involved is part of it? Because it does occur to one that if Mr. Shedd is right, and no questioning can take place until a solicitor is present, the Scottish system couldn't live with the short 6-hour period. I mean, let's take a person who's arrested or brought in rather at 2:30 in the morning. It might be quite unrealistic to expect a solicitor to turn up at 2:45, and you may have to wait until 6 o'clock in the morning, and then you've got to have some period for the questioning to take place, and you would have to extend the 6-hour period, and you'd have to sell to the public it's got to be extended now to 10 or 12 or something like that.
I think there would have to be considerable and indeed intensive consideration as to what changes would require to be effected to make any period of detention practicable and effective. If that period was to be. The period is very short. It is not a period that relates to the period of interrogation or questioning that takes place. It is a period which runs from the point of detention.
Oh, yes.
So if I'm arrested in Sucky Hall Street in Glasgow at midnight, I should say detained rather than arrested. If I'm detained and taken to a police station, the time that it takes to move there in the car, to be questioned initially and thereafter to be processed at the charge bar, all intrudes into this period of 6 hours. So it is a short period overall in relation to the operation. My Lord referred to the impact of, and my Lord Roger referred to the impact of what these safeguards might be if the decision was made that these procedures required access to a solicitor. And again, I would return, and this time in the written submissions, you'll find a further quote from Hume, which emphasises the need not to look at one isolated aspect of that. And I would submit, my Lords, that by looking at that one particular aspect, that it is an approach which essentially has developed into something of a muddle, if we look at Saldus, because of what is said.
But I mean, supposing, you admit yourself, supposing that pressure were put on somebody to make a statement, it wouldn't make any difference how many other safeguards there were in the system. The person would still, that wouldn't cure it. I mean, the question is, what do these other safeguards do in relation to this particular problem? I mean, that's the difficulty.
The other safeguards, I would suggest, my Lord, can neutralise the effect of that, because although the presence of a solicitor is something which may enhance the rights of the accused to silence and against self-incrimination, it is not, in my submission, the only mechanism by which it can be achieved. And that's why I would hope, my Lords, to take you through the somewhat idiosyncratic aspects of the Scottish criminal justice system.
By which what may be achieved? You said by which fairness. It may.
the protection of the accused's rights, the respect for the accused's will, so that there is no evidence extracted from the accused in defiance of his will.
But, yes, I see. I mean, if that's the ultimate test, then really you're saying Saldus doesn't introduce any requirement of legal advice at the outset, at least so it doesn't render a trial unfair simply because of the absence of legal advice. So the only question is whether the legal advice was in some way extorted or oppressed or obtained due to unfair influence.
Well, if there were any of those aspects, my lord, then clearly the common law would operate in terms of admissibility.
It'd be out anyway, yes.
Yes, and they would be excluded. And what I would hope to submit to my lords is that if looking at Saldus and indeed any of the other cases which have been cited by my learned friend yesterday, you were to transport those cases into the Scottish system, the courts in Scotland would arrive at precisely the same conclusion as Strasbourg in terms of the exclusion of that evidence on the basis of the common law of fairness. It is simply a different approach which would arrive at the same destination.
I mean, if Mr. Shedworth, then as I understand it, prima facie, the Strasbourg court says that the failure to give a chance for advice in advance means that the person is not informed when he makes any admissions. He doesn't do it in an informed way. So any admissions he makes are not informed. It's the lack of being advised before he makes them. Now, is there anything in the Scottish system which supplies something which supplies that particular, a remedy for that particular
I would
omission?
take issue with the submission that my learned friend made about that decision being informed, because informed understanding, it goes to the heart of free will. And what I would submit is the absence, for instance, of the adverse influence in Scotland means that the choice which an accused has in these circumstances is a straightforward choice. It doesn't have the fundamental dilemma which was characteristic of the case of Murray. It doesn't require an in-depth knowledge of the legal implications. It only requires that the accused's statement which he makes in response to the caution is one which that he understands the caution and that he knows that he has the right of silence and that is respected, that he does not require to incriminate himself. And if he understands that, that is a choice which he should be able to make freely and without any subliminal pressure or pressure from coercion, deception, or any other influence which can be brought to bear.
Is somebody who happens to have experience of the English legal system, who is arrested in Scotland, informed that no adverse inference can be drawn from his silence?
He would be cautioned on the basis of the Scottish caution.
Yes, but I mean, that simply tells you don't have to remain silent. He may have in the back of his mind what he's read in the newspapers or what he knows from his experience.
He may, but if he does not understand the nature of the caution, my lord, then that would be an issue which would go to the fairness of it, and the court would examine and scrutinise. If his position is to his solicitor thereafter, I didn't understand that I could remain silent because I come from Manchester, where the adverse inference applies, and I know that if I stayed silent, there may be difficulties with that, then that is a matter which his solicitor could put before the Scottish court, for the court to take into account that the accused did not understand the nature of the caution because of his background. And the court would look at that in the round and determine whether or not it would be fair to admit that admission on the basis of that understanding.
Has there ever been an occasion when, on that basis, such admissions were excluded?
I have to say, my lord, that I'm not aware of any situation where an English accused has, or an English accused as a tourist to Scotland committing a crime has been in such a circumstance where he has suggested a confusion or that matter has been raised. It's not to say it hasn't happened.
Do you think that if you went into the highways and byways of Scotland and asked people whether any adverse inference can be drawn from silence in a criminal trial in Scotland, the populace would come back with an answer which would be informed?
I suspect that they might be more influenced by what they see on American television, my lord, which is the Miranda rights, where they think they have a right to an attorney and all sorts of other rights which flow from that.
Do you think they would know? What's the answer?
No, I think, my lord, the position is what they know when they go in there is one thing, but the police have to assume that they know absolutely nothing. And if the police, through the caution and through the process of advising them of their rights, do not arrive at a situation where the accused understands the nature of the caution which is being administered to him at that point in time.
He's only told he hasn't got to speak, and that's all. I mean, the words, we've seen it. You've seen it thousands of times.
Yes.
But what does it? I mean, it doesn't go very deeply, does it?
But does it require, with duty to respect, my lord, to go deeply? What it requires is that the accused understands that he has no obligation to say anything, and that anything he does say may be used.
So it would add nothing to have a solicitor there beforehand.
I'm not suggesting, my lord, that having a solicitor there would not be a comfort, might not enhance to some extent how you might feel about that. But that's about volition as opposed, or motivation as opposed to
the precise words of
comprehension.
Saldus are that the presence of a lawyer is required to help to ensure, among other things, to help to ensure respect of the right of an accused not to incriminate himself.
Yes.
Are you submitting that the caution supplies that indispensable assistance that Saldus clearly believed was necessary?
I'm not suggesting that in isolation a caution can achieve that. It would depend, my lord, on the individual. And that's again where I would have to, and if I could move to these other safeguards to explain why that in isolation is not good enough simply to stop there. Because the court looks backwards at whether or not did the individual have learning difficulties, were they inebriated, whether because of their age and the fact they were a minor, were they overwhelmed, was the question put by the police officer simple, was it something which might have raised cognitive difficulties. That exercise is a sophisticated exercise of checking, which the Scottish courts do day in and day out, with expert psychologists and psychiatrists deployed by defence and by the Crown to look at whether or not the accused truly had a proper understanding of the caution and of its nature. And it reinforced, not simply by the caution, but whether you understand the caution. My lords will recollect from the case of the appellant, not only was he cautioned on 3 occasions before he was interviewed, but he was also reminded that he was under caution and asked again, did he understand that?
Surely the whole premise of the Thompson report is that accused don't fully understand their rights, because if they did, they wouldn't speak as much as they did.
I'm not sure, my lord, that's necessarily the case, because I think as the research for the Phillips on the exercise of pace was concerned, even with the presence of a solicitor, accused will indeed make admissions during the course.
But I'm asking you about the premise on which Scottish law is presently based, which is the Thompson report, and the reasoning there seems to be flatly that which I mentioned.
Yes. I think, my lord, that I simply absolutely acknowledge that the purpose of Section 1415 interview under caution is to explore with the accused what his position is, subject to his right and respect for his right, not to obtain that again in defiance of his will. That may be to ascertain whether or not the individual was involved in this matter, but it might also be that he may be innocent and there may be another person. It's intending to discover, it's a discovery of the truth of the matter. Now, if the police hope optimistically that there will be an admission in those circumstances, that is not something which requires to be apologised for. The accused is not, or suspect at this stage, the detainee, is not a no-go area for the investigation of crime.
We're going to have to look very carefully at Saldus at some point in our argument.
And I hope to do that.
When we're considering checks and balances and so on, as Lord Roger has been suggesting to you, it only really makes sense if you understand exactly what Saldus was directed at. I mean, there are passages which suggest that what they were really concerned about was coercive treatment.
Yes,
now, if it's that, it may be that videoing and tape recording is an answer to that, because the whole thing can be tested at trial. There's no hint, I think, in the narrative in Saldus that there was any such system in the Turkish prison. Now, it may be that if they'd concentrated on that, which they didn't have to do in that case, they might have said, well, there is an answer to it there. But let's come to that in due course. But it does look to me as though all these discussions are rather in the air if we're not focusing on exactly what it is in Saldus that's creating the problem.
Yes, my lord. And indeed, I'm reminded, as my Lord Kerr pointed out, that in Saldus, reference was made about the respect for the rights in that context, with a backcloth of an environment and history in Turkey, where there was serious concern repeated by the CPT, Committee for Prevention of Terrorism, about the circumstances and the persistent history of alleged ill-treatment of individuals detained in Turkey.
One has one's concerns about Turkey, but of course the fact is that Saldus applies throughout all the states parties to the convention. So one has to assume that what they say there applies generally to Scotland as well. but it's important, I suggest, to know exactly what the point of concern was, or the points of concern.
Yes, and I will come to that, my Lord. If with your Lordship's indulgence, I may look at the safeguards which are in existence in Scotland at this stage, because I think it's important to look in detail at those checks and balances, and then determine, as His Lordship Lord Roger has pointed out, to what extent these can be seen as providing mechanisms to protect the rights of the accused, other than the presence of a solicitor.
The right not to incriminate himself, which I'm interested in.
Yes.
I mean, that's really claimed it as the fundamental right not to incriminate yourself. Well, I mean, it could be in part, and obviously is in part, not merely, a right not to be coerced into self-incrimination, and obviously Saldo says ample about that, but isn't it also a right, in effect, to be told by a solicitor that, generally speaking, it's a right that you would be wise to invoke?
I would submit, my Lord, that it's not that. That might be a mechanism for protecting and ensuring that that right is respected, particularly if you're in a coercive environment, such as may have been suggested in the Turkish environment. But it may be that it's not necessary in other jurisdictions where those concerns do not exist. And one thing the Committee for the Prevention of Terrorism did not express any concern about was serious ill treatment of persons who are detained by the police in custody in Scotland. There is no concerns. There is no history of that from the CPT as we have in the environment in Turkey. And therefore, yes, it may well be a mechanism for achieving that result, but it is my respectful submission not the only mechanism, and that the Saldu's case is difficult insofar as it's so ferociously focused on a history of Turkish cases and comes in the culmination of these state security court cases in Turkey, that it takes a proverbial hammer to the whole situation across Europe, causing other systems which have developed well and other types of protections, and simply cast aside on the face of it what those protections might be, and has not given consideration in a very similar way to the Horncastle and Al-Khawaja cases, my Lord, where it's looked at in the context of one particular jurisdiction, but is not looking much more comprehensively at what is available elsewhere. It assumes that there is only one mechanism for achieving that result. My Lords, Hume is also worthy of a second quote, if I may, regarding this approach, which is not to look at this particular rule, not to look at the aspect of the solicitor in isolation, but they need to look at it in the round. When he says, again, at Commentaries, Volume 1, page 5, that it is surely a short-sighted wisdom which attends to the several points of practice separately and by themselves. It's to be found at Volume 9, my Lord, page 248, tab 248. Whereas nothing is more certain than that every one part has more or less relation to another, and that many things which considered singly may seem to be too rigorous or too indulgent are, however, when examined as parts of one whole, found to be neither way excessive, but quite suitable and proper, being coupled to other provisions of an opposite tendency, which serve to counteract them and to hinder the evil that might otherwise ensue. And I would submit, my Lord, that peroration, essentially, is a summary of the Crown's submissions, that there are capable, from the other safeguards and checks, methods by which the very same protections to Article 6 rights may be achieved in the Scottish context through the means which are in existence there. First of all, looking at Section 14 itself, the provisions there, as I've mentioned already, contain a number of limitations. But the whole context in which they operate is also important. There are procedural limitations which mean that trials must take place at a very much more accelerated rate than many jurisdictions across Europe, where in a serious matter an accused must be indicted within 80 days of committal for trial, and the trial must commence within 140 days of that appearance.
There are all sorts of protections to defendants in the scheme, but as has been pointed out, we're concerned with protections which impact on the thing we're really interested in, which is the right to protect, right not to incriminate yourself.
Yes.
So how does the fact that trials come on quickly, how does that impact on that?
I think it's part of the whole process. If I thought I was going to languish in a jail for 3 years, my Lord, it may well be something which might motivate me to say something to the police rapidly in an attempt to get out of there. A short period before trial is something which may influence you subliminally as to what the likely outcome is to be. I'm going to be here, if it's a summary matter, for 40 days in custody. I'm not going to be here, as is commonplace in Europe, for 18 months to 2 years in custody prior to the commencement of my trial. So the knowledge of that, the existence of that factor may be something which would impact and take into account. It may be somewhat peripheral, but it is nonetheless one of the variables in the Scottish system which has to be looked at. There is also, my Lord, of course, the existence of the law of corroboration in Scotland. There is no prospect, my Lord, of achieving a conviction or being convicted on the basis of an admission on its own. Even where a statement is admitted in evidence, an accused person in Scotland may not, by reason of the fundamental evidential requirement of corroboration, be convicted in Scotland, subject to the exception of the special knowledge confession, which requires to be corroborated by other facts and circumstances.
Well, that would be fine if in Saldus one had found that the individual was convicted on his own confession, but there appeared to have been quite a lot of other evidence there,
yes,
and that didn't deter the court from reaching the view it did.
It didn't cure the deficiency in Saldus because the circumstances in Saldus were so grossly unlawful, my Lord, with the greatest of respect, that it couldn't be cured. And that indeed, had Saldus taken place in Scotland, there would not have been a prospect of him being prosecuted on that period in detention, in isolation for 3 days, being questioned in those circumstances. And of course, the Terrorism Act in Scotland would apply to all of the terrorist cases in Turkey, where there would be an immediate right of access in circumstances similar to Saldus in Scotland, should that case take place there. So we're not talking about a distinction in that approach. However, although corroboration or other facts and circumstances could not save a case so fundamentally deficient as in Saldus, there have been other cases where the court has taken cognizance of the existence of other aspects of evidence in Strasbourg, where they have gained support from other facts and the painting of a banner, the handwriting evidence, the forensic evidence is referred to in some of the other cases in a way which supports, albeit that it might not salvage a situation where there was a fundamental and very profound breach of an individual's rights. So corroboration is a very important part. It's not a theoretical or illusory protection in the Scottish context, my lords. If I say that at least 1/3 of all rape allegations in Scotland are marked no proceedings by the prosecution because of the absence of corroboration, it will be an indicator of the extent and the influence that can have on what results in prosecution in court. So corroboration does play an important part to ensure that there is a separate independent check to reinforce the conviction. And of course, in the case of the appellant, we didn't simply have a conviction based on his own ipse dixit. We had corroboration by reference to the eyewitness evidence which was available from the father and the son in the case. More particularly, evidence of previous bad character is excluded, similar fact evidence is excluded, and therefore the accused in the Scottish context enjoys a protection of his right of his presumption of innocence, which is not particularly common across the European jurisdictions, where those factors and dimensions will be explored in the context of the trial. The common law of fairness, of course, is the major factor regarding the safeguards and checks which are deployed in the protection of the accused against unfairness in the circumstances of any alleged confession in the absence of a solicitor. Section 14 must be set firmly in the context of that fundamental requirement, and I would refer, my lords, to the case of Cadder against Her Majesty's Advocate, 1996, SLT, at page 1100, and I would refer there to Volume 1. I would take my lords to this authority.
You'd like us to look at the text, would you? So this is
Volume 1, tab 8, my lord.
I remember the case very well. And
yes, my lord.
It was one where the interview with this young woman was fully tape recorded, and one had pages and pages of the interrogation which she was subjected to.
Yes.
So it is a fairly powerful example of the value of having a tape recorded interview, and one could see the extent to which pressure was being put. I mean, it wasn't she wasn't being, as it were, physically physically harmed in any way. It was just simply the sheer pressure of questioning, and it went on for ages and ages, and it was a particularly severe example.
Yes, as my Lord in the Chair has pointed out, indeed my Lord Rudge referred to, tape recording and indeed video recording, which is now becoming more commonplace in Scotland, is completely absent in the Turkish system. Many of these confessions, which are characterised by allegations of duress, or indeed beatings or threats or deception, would not take place in the Scottish context because of the tape recording, unless something untoward is alleged to have taken place prior to the arrival at the police station.
Well, I think the point, with respect, might be better put. I mean, I don't know, we're in a position to make allegations about the Turkish system, but you could say...
The allegations of these...
You could say that in Saldus, the Strasbourg court did not examine and consider the extent to which tape recording might provide some kind of safeguard. Of course, it doesn't meet the point that has been put to you repeatedly about the absence of solicitor present to express and explain the importance of the right to silence.
Yes.
But at least, and Cadder is an example of this, if it's tape recorded, it can be tested in court as to whether the questioning as a whole was fair or not. Yes. And there may be cases where one might be able to conclude that the process was conducted with scrupulous fairness. And cases where that didn't happen, of course, would be weeded out simply by being able to look at the transcript.
Yes, my Lord. And indeed listen to the tape itself.
Yes.
Because both the tape and the transcript would be lodged, so both the judge would be in a position to hear any nuances or any aggression or any latent factors which may not come across in the transcript itself can be listened to where the tape is played for the jury and for the judge.
This, of course, is true, but it certainly was nothing to do with what Lord Thompson was thinking about, because, of course, tape recording came in long after Lord Thompson's report.
Yes, but before the commencement of the Human Rights Act, my Lord, and therefore, in terms of those cases which would be affected by the Saldus ruling, it would be commonplace for tape recording to take place.
Certainly, yes.
Indeed, the absence of a tape recording in Scotland in a serious case would be looked on, I think, very grimly by the court.
Oh, absolutely.
And the notion someone would make an admission which was in any way incriminating in a matter of importance without the tape recording is subject certainly of robust comment. Should there be some form of spontaneous confession on the way to the cells or indeed on the way to the police car? My Lord in the Chair, in the case of Cadona, as Lord Justice General, articulated the test that applies in Scotland. And if I may read this, the basic test, which is to be found at page 1005, paragraphs A to F.
I don't think we have the pages very easily visible on our copy.
I apologise for that, my Lord.
My copy doesn't seem to show any pages. How far into the report is it?
It's the last page of the print, my Lord, before the...
Last page?
The last page of the left-hand column.
Yes.
How does the paragraph start?
The basic test.
Very top
Top
of
of
the
the
page.
page.
Very top.
Line
My
3.
Lord. Yes. The basic test which has to be applied in this case is well settled. In Brown against Her Majesty's Advocate, Lord Justice General Clyde said, "It is not possible to lay down ab ante the precise circumstances in which answers given to the police prior to a charge being made are admissible in evidence at the ultimate trial or where they are inadmissible. This is so much a question of the particular circumstances of each case, and those circumstances vary infinitely from one another. But the test in all of them is a simple and intelligible test which has worked well in practice. Has what has taken place been fair or not?" The observation in the last sentence of this passage was quoted with approval in Hartley against Her Majesty's Advocate, and again in Lord Advocate's reference number 1 of 1983, 1984 Scottish Criminal Cases report, where Lord Justice General Emsley again said that the test was a simple and intelligible one which had worked well in practice, but the simple test must never be permitted to become a formality, especially where the suspect, due to age or mental impairment or other disability, may be vulnerable under police questioning. It is important to remember that the accused is not a compellable witness at his or her own trial. Fairness demands that he or she should not be induced or forced by police questioning to make a statement to them which is incriminating. As Lord Hunter said in Her Majesty's Advocate against Mayor, in order that a statement made by an accused person to the police may be available as evidence against him, it must be truly spontaneous and voluntary. The police may question a suspect, but when they move into the field of cross-examination or interrogation, they move into an area of great difficulty. If the questioning is carried too far by means of leading or repetitive questioning, or by pressure in other ways in an effort to obtain from the suspect what they are seeking to obtain from him, the statement is likely to be excluded on the ground that it was extracted by unfair means. Lord Justice General Emsley's definition of the words interrogation and cross-examination in Lord Advocate's reference, number 1 of 1983, as referring only to improper forms of questioning tainted with an element of bullying or pressure designed to break the will of the suspect or to force from him a confession against his will, should not be understood as implying any weakening of these important principles.
If you look at the right-hand column, about a quarter of the way down, you can see what the impression was made on our court of studying the transcript. You can see what went on there. 3 hours of questioning, and only at the end did she eventually break down and make the admissions.
Yes, my Lord. Yes. And of course, the beauty of tape recording is that it exposes any type of questioning of that nature. If the questioning is overlong, if it is persistent and unfair, if the victim is suffering from not just patent vulnerability, but latent factors which may not be appreciable not only by the police officers, but also by a solicitor late at night. Some young duty solicitor comes along at 2 o'clock in the morning and has a client who may have Asperger's syndrome. It's not something which they may be aware of. That is something which the courts are capable of looking at in some detail and with a great deal of scrutiny once the cases come to court. And many cases in Scotland do not see the light of day where it becomes clear that the accused is suffering from some form of vulnerability.
Strasbourg seems to want rather more than merely this statement is truly spontaneous and voluntary. Strasbourg, and it's really almost a philosophical difference from certainly that which underlay Lord Thompson's approach, is that you've got to be advised that this is a valuable right not to incriminate yourself, and beware of doing so. And most solicitors, I rather would suspect, would say, for heaven's sake, don't say a word. It won't help you if you do, and in Scotland it won't harm you if you don't. And they seem to want more. I mean, I have some sympathy myself with the view that you shouldn't have to be told to clam up in case you give away the fact of your guilt. But Strasbourg seemed to look at it rather differently.
I wonder whether they've actually gone quite that
well,
far.
I think that's the area, that's the chase to which we have to cut.
Indeed, that's why I think we need to look very, very carefully at whether,
yes.
whether actually, and the phrase I noted down from Lord Brown earlier on was very significant, and I suggest you and your juniors should look at very carefully, which is whether they actually do get to the point of saying there is a right to be told by a solicitor of silence which you would be wise, a right to silence which you would be wise to invoke, whether that is the point of the solicitor being present or whether it is some other feature. At first sight it looks very plausible that that's why the solicitor should be there, but is that actually what they mean?
With the greatest of respect, I'm not sure that it was about the advice. Other international committees have emphasised the value of that in the international context, which was referred to by my learned friend, Mr. O'Neill. But the focus in Saldus is very much on the Article 3 issues. It's heavily influenced by Jallow against Germany and the context in which there may be this coercive context to which the accused may find himself, or the suspect may find himself in that context. And it's seen as a protection against the coercive nature of what may take place from that environment.
Why does it not allow you to bring your security man with you instead of a solicitor?
Yes.
If that's what it's concerned with, I mean, I would rather have a security man to prevent me being assaulted. But it's not that. It's a solicitor. It's a right to have a solicitor present who's going to advise you, not to protect you from being beaten up.
Well, again, with respect, my Lord, I think the solicitor can fulfil both functions. And I think that the solicitor can fulfil the protection aspect. He may not physically protect you, depending how far he takes his duties or obligations, but he may also be in a position of reporting thereafter to a medical examiner when he came out of the cell, the fact that someone has been injured at the later stage. So there are a number of functions which the solicitor can apply. But that's not all dependent on his presence during the course of an interview, or indeed thereafter. I would submit that there are other ways and mechanisms through Section 14 where that can be achieved.
Well, you could say, in answer to Lord Roger's question, that, of course, the reason why they talk about legal assistance is because that's exactly what Article 3C is talking about. But then one asks, why Article 3C has legal assistance there? And that's the point, really, isn't it? I mean, it's there as a convention right because it has a purpose.
But again, my Lord, with the greatest respect, it's not an absolute right. It's a constituent right which is subject to restriction.
Well, it's been elevated by Saudus into a very important right, which,
yes.
Of course, in exceptional circumstances may be departed from, but it informs the way in which these things must be conducted.
Yes,
and it's the phrase legal assistance, which is repeated twice in Article 6.3c, which is so important.
Yes, and I would hope to come to why that elevation is not one which is supported by the developing jurisprudence, both in Strasbourg nor thereafter, in what has taken place following Saudus. Before I depart from the protection of fairness in the Scottish system, and I apologise if I labour, but I think it's very important that this court understands that the protections which do exist in Scotland, because those are a fundamental part of the support of the status quo in Scotland. Your Lordship, my Lord Roger, in the case of Thompson and Crowe, 2000 Justiciary Cases 173, at Volume 4, tab 65.
You want us to look at that? Because not
yes,
everybody will be familiar. Volume 5, 4.
464. Oh, well,
You give us these references rather fast, or that. I think these volumes are extremely heavy to extract, and we need to be told again, I think, which one we should be looking at. It's Volume 5,
it's
tab...
Volume 4, tab 65.
Volume 4 starts at tab 66. So what do you want?
Sorry, my Lord, it's Volume 3.
Volume 3. And so we're tab 65, is it? No, not right. Yes, it is.
Thompson Crowe. Well, this looks a very authoritative court now. What's going on here?
In this case, at page 202 of the opinion.
Yes.
My Lord Roger, looking at the Scottish system, indicated the judge will exclude evidence of a statement if it was taken in circumstances which render it inadmissible under any rule laid down by the law. In other cases, the judge will admit the statement if the Crown satisfy the judge that it would be fair to do so by proving that the statement was freely and voluntarily, I think that should be, my Lord.
So which paragraph are you reading?
This is page 202, my Lord.
The summary?
Yes.
Paragraph?
7.
7. I'm sorry, I didn't hear the 7.
Apologies, my Lord.
Yes?
It was made freely and voluntarily and was not extracted by unfair or improper means. The emphasis on the spontaneous and voluntary nature of any admission is a crucial part of the framework under which any admission will be examined, whether it's obtained in the context of Section 14 of the Criminal Procedure Act or in any other context.
Well, for the court to perform that duty, it has to be sufficiently informed about what was going on.
Yes, my Lord.
Doesn't it? And you may get, of course, some background information from the video and the transcript and so on and so forth. But we're still looking for reassurance on the initial point about the right to silence and the understanding of that right, beyond the fact that the caution has been administered.
Yes, my Lord.
The police practice is to administer the caution in the formal terms, and that's pretty well it, isn't
yes.
it? You see it's read out, but there's no sort of further elaboration of it, is there?
It would, of course, be open to any solicitor to submit that his client has not understood the caution. That would be part of the preliminary proceedings, where he can raise the issue about comprehension. my client did not understand the significance of this phrase. He was not capable because he has a limited IQ, because he was suffering from chronic alcoholism at the time and he had organic brain damage, or because he was too immature, or because of infirmity, he could not understand it, or because of the complex sentence structure utilised by the police officer, or the police officer didn't deploy the normal phrases. And it is a feature of criminal proceedings in Scotland to have a psychologist present who will give expert evidence that the accused was not capable of understanding the specific words issued in a caution.
Present where? At the trial?
A preliminary hearing, my lord. There would be a preliminary hearing in those circumstances at which the court would hear evidence as to whether or not the accused was capable of understanding where it's raised. And where the accused raises that, the onus shifts to the prosecution to prove that he did understand. The Crown is then obliged to show that the accused did understand and appreciate the nature of the caution.
But I mean, the caution that you get early on and when you're detained, I mean, that tells you that you don't have to say anything. Yes. Now, if then, stupidly as events turn out, you go and confess all, and that is maybe a determining factor in your being found guilty at the end of the day, you've waived the right to have kept quiet. Is that what you've done?
I wouldn't suggest waiver in the legal analysis.
But why isn't it actually back to back with the concept of waiver, which itself requires that you're informed? And whether you look at it from waiver, which is the other side of the coin, or from you need to know that there's a right, and you need to know its value, and you need to know how important it is in these early hours of detention. You know, not just a cough, because that's the thing that really all your instincts tell you would be a nice way of getting it off your conscience.
Yeah, again, with respect, my lord, not all accused wish to hide behind that right, that important fundamental right. There are those who, filled with remorse or filled with may wish, as a matter of volition, notwithstanding the knowledge.
I have some sympathy with not having to tell them that they'd be wise to keep quiet. But I'm just wondering if Strasbourg allows that. That seems to me to be at the heart of the case.
Yes, my lord. What I would suggest is that what is curious about Saldus is that if in the jurisprudence which has been developed in all of the years before then, looking back from Edwards and onwards, through all of these cases where admissions have been found not to amount to a breach of Article 6, what is it that's in the context of Saldus that suddenly differentiates it between that which could be acquiesced in by the courts in Strasbourg over all of these years, case after case, where there have been these admissions? What is the quality of what took place in Saldus that changes the court's position to one where it determines that the solicitor is the defining factor in terms of fairness?
Well, what it is that they have articulated the view, and I'm reading from paragraph 54 of Saldus, an accused often finds himself in a particularly vulnerable position at that stage of the proceedings.
54.
In most cases, this particular vulnerability can only be properly compensated for by the assistance of a lawyer. So that's the point. They're not talking about oppression, hectoring, and prolonged oppressive interrogation. They're just saying that most defendants, or many defendants, are, by definition, in a vulnerable position, faced as they are in the police station. They've been hauled into the police station, often very quickly and at short notice. They haven't had time to gather their thoughts, let alone to consult anybody else. There they are. They're very vulnerable. They might well understand the caution, but in their vulnerable state, they may not act in a way in which, had they got the protection and the benefit of the advice of a solicitor, they would not act.
But I would submit, my lord, that in that context, that Strasbourg's view of that is coloured by the environment and the context in which it takes place. The draconian background, the fact that someone is there for 3 days, these are all factors which are present in Saldus, which they do not find wanting in the context of other cases where the degree of the vulnerability of the accused may be different because of the environment. So if you look at the case of Saichenko, where it's at the roadside, where the accused was not free to go, but was detained by the police, in those circumstances, it seemed to be less nefarious or less intimidating than the context of the state security cells in Izmir. Now, if that situation can be looked at in the context of the Scottish situation, where you have a very short period of detention for questioning, you have tape recording, you have caution, you have no prospect of an extension of that 6 hours, and where you have the knowledge that your solicitor has been contacted and knows you're in the station, and you have a next of kin.
Are defendants told that? Are they told when they're detained that we can only keep you for 6 hours?
I'm not sure whether, as a matter of practice, that takes place, my lord.
Well, I mean, unless it doesn't.
It's not part of the statutory provision that they must be advised of them.
They may well not be aware of it. They may think they're there for a long time. I mean, may the proof of the pudding be slightly in eating, because the fact is that I imagine a significant number of defendants wish subsequently they hadn't said anything at the outset.
Some may indeed, and it may be a critical and significant piece of evidence. Others may wish they had put a defence at that stage because it is then capable of being investigated by the Crown and may be constant with their innocence. Or indeed may find that someone else was a perpetrator rather than them. There may be benefits to an accused from an admission. It's not always.
That was the optimistic thinking behind judicial examinations, and proof of the pudding is in eating. Hardly anybody says anything in judicial examinations, as we know. And people have tried and tried over the years to see whether it could be reformed in some way to get them to say something, but they don't, as you know, Lord Advocate. They say, on the advice of my solicitor, say nothing.
But that's a matter of choice.
Yeah, but it's what they do when they're advised.
Yes,
and the question is, one just might ask, supposing they were asked, given the same advice before they were ever interviewed, would they say anything? The answer is they probably wouldn't, because they don't say anything when they go in front of the sheriff, when they've been advised not to.
They may not. It may be a different position. But the question is whether or not the motivation which the solicitor might address, as opposed to the free will of the accused, is what the court is concerned about. And it's the spontaneity, it's the free will of the accused. It's not in defiance of his will that this is a minimum right, my lords. It's not an absolute right. It's capable of restriction. The right to silence is not one which is not capable of being restricted. And my lord, Sir John referred to paragraph 54. But the sentence commences, in most cases, my lord. Why in most cases? Why not in all cases?
Because there may be very special circumstances, terrorism being one of them, where you may have a good reason to restrict it.
What I would submit, my lord, is that there are good reasons in the Scottish context because of the other protections.
That's exactly, as I understand it, is exactly what the Strasbourg case sets its face against. It doesn't seem to suggest that you can have a general system. It says your general system should be opportunity for advice with exceptions, whereas you're saying it can be general, no advice in advance, perhaps with exceptions.
Well, I'll come to those 3 paragraphs in Saldus as to precisely what it says. And my initial submission, my lord, is that it doesn't say just precisely that, but as McLean, their lordships McLean has said, it is a couple of 2 unfortunately ambiguous paragraphs regarding just precisely what it does say and the extent to which that is the reach of Strasbourg. And if that is what Strasbourg is saying at this point, then I would have a separate and distinct submission to follow that as an Estral position.
That's really the heart of the case, I think, isn't it?
It is, my lord. The fundamental rule, my lord, that a statement will be admitted in evidence only if it was made freely and voluntarily and was not extracted by unfair or improper means is secured in Scots law by the statutory and practical safeguards inherent in section 14, by the absence of any compulsion on the suspect to speak. There is no compulsion inherent in the caution which is administered in Scotland, irrespective of whether or not there is a solicitor present or not, unlike that which is administered under PACE, where there may be seen to be an inherent motivation to speak on the basis upon the administration of that caution. It is also secured by statutory and other safeguards which apply after charge and by the legal and practical safeguards attendant on the trial process. And therefore, Section 14 may only be put into effect if the police have reasonable grounds for suspecting that the detainee has committed or is committing the offence which is punishable by imprisonment, which relates to its proportionality, It's subject to a maximum duration of 6 hours, which I've already mentioned, not capable of extension. Nor can a suspect be redetained on the same grounds or on any grounds arising out of the same circumstances. Once detained, the suspect must be taken as quickly as is reasonably practical to a police station or other premises, but as I mentioned earlier, the detention starts from the point of the taking into custody at the locus or wherever the accused or detainee is seen. The detainee must be released if there are no longer reasonable grounds for suspecting that he has committed or is committing an offence, and at the time when a constable detains a person under Section 14, he is obliged to inform him of the suspicion, of the general nature of the offence which he suspects has been or is being committed, and of the reason for the detention. The detainee is entitled to have intimation of his detention of the police station or other premises sent without delay or with no more delay than is necessary in the interest of the investigation, the prevention of crime or the apprehension of offenders to a solicitor. In addition to intimation to a solicitor, the detainee is also entitled to have intimation of the fact and place of detention made to one other person reasonably named by him, for example, a family member. And again, all relevant details of the detention must be recorded by the police, including the times when the detention begins and ends, when the suspect arrives at the police station, and when he is informed of his rights to have intimation made to a solicitor.
Perhaps, for those who are unfamiliar with it, it might just be worth looking at Section 14, subsections 9 and 10, just to see how the statute puts it, because it is quite carefully set out what can be done. It's really subsections 7, 8 and 7, 9 and 10. Where is a convenient place to look at it? I'm looking at the report in the claim.
Page 7 of the Advocate General's here.
Volume 8, my Lord, at tab 200.
Excellent.
Yes.
And then looking at subsections 9 and 10, my Lords, it sets out that the detainee is under no obligation to answer any question other than to give his name, address, date and place of birth and nationality. He is to be informed of this both on being detained at the locus, wherever he is detained, out with the police station, and on arrival at the police station.
So it's not just the simple form of caution, then, is it? There's a particular statutory formula for this process, is there?
There's a statutory formula at that point, the point of detention, and when the individual arrives at the charge bar of the police station, when the forms are completed by usually the station officer or the bar officer at the charge bar. In practical terms, my Lord, once detained, the suspect will usually be taken to the charge bar of a nearby police station. The detention forms recording the matters required by Section 14, subsection 6 will be completed by the duty officer, who will be an officer other than the arresting officers. And this procedure will often be recorded on CCTV monitoring the charge bar area, which again is another form of practical safeguard, which can be looked at in contrast to what may take place in some of the countries which have been the focus of concern by the European Court of Human Rights. So, for instance, the London Road Police Station, where the appellant in this case was present, would have a CCTV camera over the charge bar, which would show the individual as he arrived at the police station and allow the court thereafter, if there is an issue regarding an allegation of assault or poor behaviour on the part of the police officers, to see the demeanour of the detainee as he arrives at the police station, examine his state of sobriety, or whether or not he's drugged, or whether he's distressed, patently distressed, or whether he's injured in any way, or at least patently injured. It would also afford a facility and opportunity to look at the demeanour of the police officers towards the detainee at that point. Where the investigating officer has reason to suppose that a suspect in detention is vulnerable by reason of mental disorder or learning difficulty, he should arrange for a medical examination of the suspect in order to establish whether he is fit to be questioned. If so, arrangements should be made for an appropriate adult to be present while the interview takes place.
Where do we find that?
Sorry, my Lord.
Where do we find that?
That's referred to, my Lord, in the Scottish Office Guidance at Volume 10, tab 280, which is the interviewing people who are mentally disordered, appropriate adult schemes, and the ACPOS guidelines on the interviewing of suspects and admissibility generally, at Volume 10, 262. So if it was a case, my Lords...
Not too fast, I'm not sure I found this yet. 262, is it?
Yes, my Lord. That's the ACPOS guidelines, and 280, Volume 10, for the Scottish Office Guidance. The absence of an appropriate adult, again, my Lord, would be the subject of comment in circumstances where the solicitor thereafter felt the accused was suffering from a learning difficulty which hadn't been appreciated. And indeed, confessions or admissions may well be excluded by the prosecutor once it has become clear that that situation had not been appreciated by the police at the time of interviewing. The non-extendable 6-hour time limit in Section 14 may, I would submit, my Lords, be contrasted with the provisions of the Police and Criminal Evidence Act of 1984 in England and Wales and the Police and Criminal Evidence Northern Ireland Order of 1989 regarding detention of suspects in England, Wales and Northern Ireland, respectively. Section 41, and I appreciate, my Lords, I'm certainly not an expert in any of these provisions. My Lords will be more familiar with them than I am. As I understand it, Section 41(1) of PACE permits a person to be kept in police detention for up to 24 hours without being charged, and a person released from detention without charge may be rearrested and detained anew for the offence for which he was previously arrested and detained if new evidence justifying further arrest has come to light. I understand that the initial 24-hour period of detention may be extended to 36 hours by a police officer of superintendent rank or above in relation to indictable offences, and again for a further period up to 36 hours by warrant of a magistrate. Again for a further period again of 36 hours with a further warrant from a magistrate for a maximum period of 96 hours of questioning, potentially. That has to be seen in the context also of the right of access to a solicitor during that, but certain circumstances will permit the delay or the absence of a solicitor in the English and Welsh context as well. Section 14...
Could you, sorry to detain you, can you just elaborate a bit on that last point? I'm not familiar with the way Section 41 operates. I mean, there is a right of access to a solicitor from the outset under
there is a right, but it may be delayed in certain circumstances, and I will explain that, my Lord. I'm just about to come to the circumstances.
Is that in the statute or is it in practice?
It's in the statute, my Lord.
Right.
And of course, that came from the Phillips Commission, that recommendation, my Lord, in 1984, when there was no attempt by Parliament at that stage to amend sections 2 and 3 of the equivalent Scottish provisions. Section 14, my Lord, has an absence of any compulsion to speak, with the limited exception of giving his name and address, place of birth or nationality. The detainee has no compulsion, direct or indirect, to speak unless he wishes to do so. Before interviewing the suspect, the police should administer a caution to the effect that the suspect is not obliged to say anything, but that anything he does say may be used in evidence. If the suspect has not been cautioned evidence of what he has said will not generally be admissible. So the situation is, my lord, that the detainee is likely to be cautioned at the locus. He will be cautioned again on arrival in terms of the Section 14 provisions, and then before any interview takes place will be the subject of a common law caution, which will be tape recorded, as will his response to that caution, and his confirmation or otherwise that he has understood the caution which has been administered to him.
So that means in the typical case it will be administered 3 times, twice under the statutory formula and once at common law.
Yes, my lord. It is not my position that if what else took place was unfair, that the administration of cautions would cure that. But these are factors which are clearly very important. And the caution is not something which is esoteric or terribly legal in its significance. I would suggest it's fairly commonplace, indeed for most teenagers, to be aware from detective programmes and more generally of the implications of being arrested. It's a very significant diet of police television programmes of people being arrested across the bonnets of cars, usually are accompanied by the administration of a caution.
But we don't resort to what is apparently the position in Turkey, according to paragraph 14 of Saldus, that the arrested person there signs a form stating that he's been reminded of his right to remain silent. It's done purely orally.
I think, my lord, that is an admissible of evidence, but in the absence of the tape recording, which records the accused's understanding, records the demeanour of the accused during that interview, and whether or not he has understood it, I think it's a further protection there that is quite distinct from that which exists in the Turkish system. I think in one of the Turkish cases, the accused was illiterate. I think the case which was referred to by my learned friend Mr. Shedd yesterday, he didn't mention this particular aspect, but it was a thumbprint by the accused on the written form. And so there are various forms which could be completed which would not provide any form of objective protection. But the recording, the electronic recording of the administration of the caution is a further protection, in addition to the completion of forms by a bar officer or another police officer in the station.
So if somebody said, Lord Advocate, you've got this system, it's marvellous, it's got all these forms, it's got all these cautions, it's got all these rules about not missing things taken under pressure and inducements and all these things, everything you've said. And then somebody said, well, and also, if you're arrested, then you have a right to have a solicitor come and speak to you and give you legal advice. And then he said, well, there's just this bit in the middle, Lord Advocate. Why is it that you're not entitled to have a solicitor, consult a solicitor, before you are interviewed? Why not? And if that was the question, would you find the answer in the passage in the Thompson report, at paragraph 4.18 of Mr. Shedd's case? Would that be the frank answer?
About standing on rights, my lord.
Well, the passage, if you just look at it, paragraph 4.18, comes from paragraph 716 of the report, but it's in Mr. Shedd's case at paragraph 4.18.
That might be part of it, my lord. Yes, it may be part of it. In the same sense that the adverse influence which applies under the Police and Criminal Evidence Act in England and Wales recognises that the accused right of silence is not absolute, and an adverse influence may be taken from that in order that he does not stand on his rights or obstructed by the advice of a solicitor.
The purpose behind not giving this right to an interview is because the idea of the interrogation is to get information, such information as the man may possess about the offence, and that may be defeated if the solicitor goes in first. Is that right? That would be the frank answer.
The position, my lord, is that the accused or the detainee may be a source of evidence against him, provided he understands it's his free will and he understands that he has no obligation to do so. It may well be, I think Thompson referred to in the passage of the report, that a solicitor may be viewed by the police as someone who may inadvertently pass information on or may give other advice to other co-accused, and therefore there were reasons for excluding, which it may be based on the individual. I think that was referred to in the Thompson report, that the concerns of the police at that time, that the nature of the investigation in some cases might require to be kept close at that point, and not to be divulged elsewhere. And that concern was part of it. But whatever the reasons are, there is certainly a recognition that a solicitor's advice might be to say nothing.
And that
yes.
may defeat the purpose of the interview.
Yes, which would seem, again, my Lord, with greatest respect, to be the purpose of the adverse inference which is incorporated in PACE.
Do we have the Phillips report that Mr. Shedd refers to in the papers? This is Royal Commission.
It is lodged, my Lord. I think it's lodged by the appellant.
It presumably is somewhere.
I think it's an extract from that report, my Lord.
277 in volume
277, my Lord.
In volume 10. Yeah. And Mr. Shedd refers to that paragraph 486.
What one of these bombs was really from? There in October was on it.
Paragraph 490 is interesting, but that's a position where public interest really requires a rather different position, and then there's a risk that solicitors may behave improperly and so on and so forth.
Yes.
But the advice, as Mr. Shedd points out in his case, really is quite different from Thompson, isn't it?
No, it's not.
Sorry, it's not consistent with Thompson.
I think it relates to the Phillips report itself. The Thompson committee looked at achieving a balance between the effective investigation of crime with the accused.
Well, isn't that so of the Commission's proposals here?
Yes, my Lord, but in the context of a different system, with different checks and balances in place in the English system. So, again, in the Scottish context, recognising a backcloth of corroboration and the requirement and protections afforded to the accused from the requirement of corroboration in Scotland.
But what's said in 489, bottom of page 99, top of page 100, surely applies. Many people are inarticulate or illiterate, particular problems with ethnic minorities. Furthermore, a person being questioned is in a position of disadvantage, unlikely to be properly aware of the legal intricacies of the situation, to understand, for example, the legal concept of intent or the application of the laws of evidence in his case, with full implication of desirability of his right to silence, or to know what penalties are likely to be for the offence for which he is suspected. All these things, only an experienced lawyer can give him this kind of information and advise him how best to proceed. Now, all that would apply, mutatis mutandis, in Scotland, would it not?
It would apply, my Lord, and if those circumstances existed, the likelihood is that any admission made would be inadmissible.
What?
If the accused did not understand the nature of the caution, had these learning difficulties.
It's the full implication of the desirability of exercising his right to silence. That wouldn't make it. I mean, all you ask is, was he cautioned? Did he say he understood the caution? Whether he understood the full implications of the desirability of exercising his right to silence is never, as far as I know, has ever been investigated.
But, my Lord, again, with the greatest respect, to what extent is that the question that the detainee must address?
Well, that's
it doesn't require to go further than the caution itself.
This is the reason why the Phillips Commission thought that he should have legal advice. That's the point.
Yes.
That's all I'm saying is that all that applies to Scotland.
The same variables would apply, but different protections would be deployed in Scotland to ensure that the same protections can be afforded to such individuals.
I don't see what protection would come in for that bit about the desirability of exercising his right to silence. It's never investigated. You couldn't cite me a single case where that's been ever been taken into account?
It might not be on this specific, but in relation to the accused's general understanding and knowledge of language, or in relation to the complexity of the subject matter, my lord, it could not be the position that in the middle of the night an accused is in a position to be advised by a solicitor of the complexities and the sophistry of, let's say, for instance, a money laundering charge or something entirely complex at that stage, with the hope that the accused will understand the implications of it. It is much more likely that this advice that would be given would be simply to maintain the right of silence.
Yes, that's exactly the point.
If he can't explain the legal intricacies, well, then he can tell his client, don't speak.
Yes, but as a client may choose to do, if he is properly cautioned by the police in those circumstances.
Halfway down, paragraph 4.90, we do not consider it sufficient justification for withholding access that a solicitor may advise his client not to speak. That's the suspect's right. So,
sorry, my lord, I had difficulty hearing that.
Page 490, halfway down that paragraph.
That is rather important.
Yes.
That view of the Phillips Commission was, of course, before the United Kingdom Parliament. Notwithstanding the view of the Phillips Commission regarding that matter, the United Kingdom Parliament, not simply at that stage, but again in 1994.
But that's when you say United Kingdom, this is when it was enacting the Scottish measures.
Yes, and in 1995 chose not to alter the situation in Scotland, recognising the operation of the other protections in Scotland, obviously, which strike the balance in a different way. And I'll refer...
Was there any debate about it?
It was a consolidating measure, so there wouldn't be, but I would not think that any Scottish Lord would allow these proceedings to take place without consideration of whether or not it was still suitable for contemporaneous Scotland at that stage.
But the 1984 Act, the PACE, was a Home Office Act, nothing to do with the Scottish Act.
But the Criminal Procedure
Act, of course,
Act,
1995, mainly consolidated.
Yes, that's right.
It was in fact consolidating except for the Law Commission reforms which were added. It was a consolidating act.
That's right.
Plus Law Commission, and Law Commission things were allowed to go in under the special rule which applies to Law Commission.
Yes, but even so, my lord, the opportunity at that stage, if it was something which seemed to be materially wanting in the context of the Scottish position, would have provided an opportunity for the Parliament to deal with it at that stage, to bring Scotland into line with PACE if that seemed to be different. But
can I just understand your point about corroboration? Is it only admissions which require corroboration?
No.
All evidence requires to be corroborated. So
there are some statutory exceptions, some minor statutory offences which do not require, like
so
litter.
If you had,
litter.
I mean, the thing is surely self-defeating. So if you didn't have these admissions, then you'd have to find corroboration of the corroboration.
Well, that's where the evaluation of what is most valuable to an accused in terms of his protections has to be looked at. Whether or not the very highly regarded protection that is afforded by corroboration in the Scottish context, viewed as a very material protection against wrongful conviction in the Scottish.
How big a protection really is it? I mean, if you've got an admission, that's usually pretty damning. You probably don't need a great deal to add to it.
Well, you require corroboration, my lord.
Yes, I know, but corroboration needn't be very much.
Well, if to the extent that 1/3 of all reported rapes where there is a complaint by a complainer and identifying an individual as a suspect cannot be prosecuted in Scotland if such an event takes place in Dumfries, cannot be prosecuted because of the requirement of corroboration, whereas in Carlisle it would be prosecuted. That's the significance of it. It is a very, very major protection, and many cases are marked no proceedings by the prosecutor, do not see the light of day because of the absence of corroboration.
But Lord Mance is right, isn't he? I mean, there have been judges who have said where you have an admission by somebody that it's such an obvious admission by somebody who's in the best position to know you don't really require very much more. The rule is you need more, but it doesn't have to be all that much, and you may get something which in itself is not very powerful but is good enough. But if there's no admission, then you've got to prove by corroborated evidence in other ways. So every time you're producing some material element, be it identification or the commission of a crime or whatever else, each of these bits has to be proved by corroborated evidence.
It may not be the nature of the crime, it could be the identification of the assailant, or it may be that the actus reus has to be corroborated, and it's particularly difficult in cases where there are no eyewitnesses. You may rely on facts and circumstances and forensic evidence as a source of corroboration, but when we come to crimes such as sexual offences against children, or indeed against adult offenders, or for that matter, murder, then you require corroboration, a second source, independent source of evidence of each material fact before a conviction can be secured. It's a very important protection which cannot be, I think, underestimated, and is one which certainly would require to be revisited, I would think, in the context of a situation where there were not admissions which were available to provide a source of evidence to support them.
I wonder if I might just pick up at a somewhat more general or abstract level this argument that safeguards that are features of the Scottish system, which aren't factors which apply in this jurisdiction or in many of the jurisdictions of the member states of the Council of Europe, what relevance that has. If one starts from the premise that the irreducible minimum of SALDUs is that the availability of legal advice is an important safeguard, might it not be said that if that safeguard is absent and admissions are obtained during detention, the disadvantage which has been identified in SALDUs cannot be offset or nullified by a tally or totting up of factors which may independently conduce to a fair trial, but which don't address that specific disadvantage?
If, my lord, that's an absolute position in SALDUs, I would accept that is an irresistible conclusion. But my submission is that is not necessarily what should be taken from SALDUs. I hope to move to that.
Yeah, well, I'm sorry, I just asked you to make the assumption that that was the premise. Yes. It may well be that you submit to us that it wasn't. But you say that, notwithstanding that these various safeguards that you have identified don't go directly to what I've said is the underlying premise of SALDUs, that nevertheless they can somehow be put in the balance in order to outweigh
it is the approach which Hume exhorts in 1819 of not looking at a single aspect of the case. Indeed, it's the same approach which Strasbourg itself has repeated almost as a mantra in many of its cases in looking at Article 6, that you do not look at a single aspect, one constituent part in isolation, but that you look at the whole. And it may well be the case that if the prejudice is such from what has taken place in the context of an admission, that it is such a gross breach that it cannot be overcome by any of the other safeguards, it would be found to be inadmissible, as it would indeed in Scotland. And as I mentioned, the Turkish terrorist cases would not be cases which in the Scottish context would be ever found to be capable of supporting a conviction in the circumstances in which they took place, because there is a right of access to a solicitor in Scotland in terrorist cases such as those in SALDUs. It is not the case that would apply.
The problem about that answer is really highlighted by SALDU's paragraph 50, the last sentence, because one notices that in SALDUs the Grand Chamber rather did recognise the jurisprudence that says that you look at one element amongst others in the context of a fair trial.
Yes.
But having said that, it still pulls out the Article 6.3c point and then builds on it. So, I mean, this is something that we just simply have to face. It's not good enough to just say, well, it's just part of an element in the whole elements of a fair trial. We've got to really work out what the significance is of the message in the case about Article 6.3c.
If it was the case, my lord, that once that had taken place, there was at that point irretrievable prejudice to the accused per se from the absence of the solicitor. What would be the point, my lord, in those circumstances, if I may say, of examining the other variables and looking at the rest of the evidence as to what took place in the context of the environment? The court need go no further than arriving at that particular point. And not only in SALDUs do they examine the whole, as they do in the cases predating SALDUs, but in the cases which follow the environment, the circumstances, the nature and degree of the period in detention, as well as the particular allegations which are made by the individual of duress or beatings or threats or inducement, are examined by the court. The court does not require to carry out that exercise if that's the case. And I submit...
If Saldus is to be interpreted as is being suggested, as I understand it, the evidence of the admission would be inadmissible. I think that's what.
Yes.
Well, if you take an admission which is obtained by duress, it's inadmissible, even though you might have umpteen bits of corroboration.
Yes.
Well, why does the existence, for example, of corroboration, why would it make this piece of evidence inadmissible?
It wouldn't in isolation, Lord. I'm not suggesting that there is one aspect of the Scottish system which itself is a panacea. If there had been something wanting in what took place, if it was inadmissible for that reason, you would exclude it. You would exclude that evidence. The corroboration may form another part of the case, which the court could look at. But again, if it was a highly significant case...
But you've talked about corroboration. Why should it cure this, make this admissible, if it would not otherwise be admissible?
It's not my proposition, my lord, that it would cure it. It is part of that larger picture. It is one of the variables or adminicals which are present in the environment in Scotland, which themselves work towards providing a protection, which means that the significance of the absence of a solicitor in the Scottish context does not take on the significance that it might in another jurisdiction.
I mean, is the submission that the Scottish system is so comprehensive in its protections against miscarriage of justice, makes it so difficult, sometimes I think over difficult, to get convictions anyway, that for your jurisdiction, Strasbourg would say, OK, it's all right to shut the solicitors out and to thereby promote the chances of getting confession evidence because the solicitors won't be there to advise against giving it. I mean, is that basically the submission?
No, my lord. What would be the position is that if Strasbourg had applied its mind, as it will require to do in the context of the French system and the Dutch systems and other cases which will come before it from other of the democracies, is whether or not those environments are such that conclusion which is reached would be the case, and whether or not, when it refers to in most cases, that the presence of a solicitor affords that protection, or that particular regard will be given to the presence of a solicitor, takes on the same significance when it is educated about the particular facts and circumstances of each of the case, in the same context as Horncastle, my lord, where, again, the broad brush approach taken to hearsay evidence was one which failed to understand the context of the English criminal justice system, had not applied its mind to how it operated in practice and what the environment was there, and which, if put into effect, would be such as to render ineffective the criminal sanctions which are in place in Scotland and make difficult achievement of the Article 2, Article 3 and Article 8 rights, which are there for victims of crime and indeed for the public interest. It's a balance which is to be achieved.
So do you say if we had solicitors advising people before they gave statements, the whole criminal justice system in Scotland would grind to a halt?
I would suggest, my lord, that it is difficult to speculate what the outcome of that advice might be. It didn't happen in England and Wales, but the difficulty in England and Wales is that there is no requirement for corroboration. It may be desirable to have corroboration in the English context, but it's not essential. Something would have to change, my lord. Of that, there is no doubt. The system could not.
So it's getting in. It's getting freely given but unwise admissions is absolutely the critical way of getting the corroboration which is required in order to prosecute crime in Scotland. Is that really the problem?
Well, de facto, my lord, it has been critical in many cases.
Absolutely, of course.
It has been.
Of course.
And that's a balance which has been struck. If it was seen as being unfair, my lord, then that challenge hasn't taken place in the last 30 years.
Well, it's happening now.
Yes.
It's happening now, Lord Advocate.
Yes, the question, my lord, however, is has Strasbourg, in that decision, applied its mind correctly? Or should it not be applied, my lord, which is my secondary submission, if my lords have formed the conclusion that that is the outcome of Saldus, whether or not your lordship should apply it, given that Strasbourg has not applied its mind to the other systems which there are in Europe, including Scotland, and the very particular protections which exist.
And it would really be, we would have to say, or would be part of it, we're saying, well, actually, in Scotland, the system couldn't work with this rule.
that what
It's
you
not,
said?
it's not to say the system, my lord. It's not to say the system wouldn't work, my lord. There would be far fewer, undoubtedly, prosecutions taking place if there were not admissions in the Scottish context, because corroboration is in itself a formidable obstacle to prosecution in terms of sufficiency.
Well, you might have to change the rules about the nature, the wording of the caution, and adopt the English formula that if you inferences may be drawn against you. Now, the Scottish system doesn't do that. I don't think Strasbourg has yet said, although perhaps it might, that there's something wrong with even that. But
that might be approached, my lord.
I mean, so there are two things now that are lined up.
It would certainly require an alteration, my lord, because
Yes.
an adverse inference from silence, which may be again seen in some contexts as something which in itself is unattractive from another perspective, where corroboration might be valued as a more significant and effective protection than a caution which has inherent in it a propulsion to speak.
But it's a change in the law which, standing current Strasbourg jurisprudence, you could make, and you could extend the period of detention and so on. So
Certainly,
these are changes that could be made.
Clearly, my lord, if your lordships were to form that view, then the action would have to be taken to review the criminal system of evidence and procedure in Scotland. And that would have to be done to adjust the system to take that into account. That's beyond doubt.
If you keep corroboration and then but introduce adverse inferences, I suppose you then have to ask if an adverse inference can constitute corroboration.
I don't think one would.
That issue would have to be addressed.
No, I think that's rather difficult to swallow, frankly, but possibly not. I don't know.
My lord, on the subject of adverse inference, if again, I can simply emphasise that in Scotland, if the suspect chooses not to speak at interview, no adverse inference may be drawn at any subsequent trial from his silence. Similarly, if the suspect chooses to answer some questions, but not others, no adverse inference may be drawn from that circumstance at a subsequent trial. So the suspect in Scotland retains the absolute right to silence whether or not the police have exercised their discretion to allow him access to a lawyer, or to allow that lawyer to be present during the interview, which they may do from time to time. Accordingly, even if the suspect has had the benefit of legal advice, no adverse inference may be drawn from his silence at interview. Again, Scots law may be contrasted with the situation in England and Wales, where the caution is you do not have to say anything, but it may harm your defence if you do not mention when questioned something which you later rely on in court. Anything you do say may be given in evidence. So in England and Wales, where an officer or superintendent rank or above has authorised a delay in an accused having access, that situation would not pertain. So in the absence of a solicitor, the adverse inference would not take place if there is that delay, and we would revert to the common law caution administered in Scotland. However, if the suspect declines the opportunity in England to consult a solicitor, or nominates a solicitor who fails or refuses to attend at the police station and then refuses the services of a duty solicitor, adverse inferences may be drawn from the silence of the individual, notwithstanding that there is no solicitor present.
Can you just, you're reading from somewhere?
Yes, my lord. This is at volume 8, section 34 of the Criminal Justice Police and Public Order Act.
Volume 8,
It's
tab.
volume 8, tab 184, my lord.
And this is section 34.
Section 34, subsection 1. These provisions, my lord, I would submit, illustrate the interrelationship in striking a balance which secures the effective investigation and prosecution of crime while respecting the rights of the accused between access to a solicitor and the question of drawing inferences from silence. Although the United Kingdom Parliament made amendments to sections 2 and 3 when it enacted this Act in 1994, it did not make provision for similar adverse inferences to be drawn from silence under detention in Scotland, nor did it confer a right of an access to a solicitor. The strong protection in Scots law of the right to silence for persons detained under this section can also be contrasted with the jurisprudence of the European Court, where the drawing of inferences from silence such as are permitted by these sections
Can you
does
give
not...
some...
Sorry, my lord.
You're saying that the Strasbourg Court allows this?
Yes, it does, my lord.
And this is authority for that?
Yes, the drawing of inferences from silence are referred to in the case of Murray against the United Kingdom, 1996.
But it's rather paradoxical. It's a strong protection in respect to the right of silence as long as it's not exercised too often.
Yes, in the case of Murray.
No, I mean in the case of Scots law. If it were exercised too often, it would be disastrous because you're saying you wouldn't get convictions.
Well, again, my lord, it is indeed exercised. The right to silence is indeed exercised in Section 14 interviews frequently, as a result of which there is no reply. There is no, the accused without a solicitor will not.
So
Clearly, I think
you're really saying it wouldn't make any difference if there were a solicitor provided, and the difficulty in providing one is purely that 6 hours is rather short, and...
It may or may not. It's difficult to speculate what advice an accused might take from a solicitor in these circumstances. As to whether or not he will say, well, essentially, I've had enough of this, I've killed my wife, my life's over and I want to go to jail. And
well, if in the light of legal advice that is said, fine.
Well, the experience of the judicial examination before the sheriff suggests that the presence of the solicitor without what one finds in Section 34 will lead to silence being exercised all the time.
It may well
and so
indeed have that
absolutely
effect.
nowhere at all. So solicitors are turning up at 3 and 4 in the morning, sitting there telling their client to say nothing, and 6 hours goes by, nothing is said, and the person's released, and that's that, and it's a whole waste of time. So, I mean, something would have to change if the solicitor were there.
I think undoubtedly there would have to be a review of the structures, the infrastructure, the provision in relation to access, as well as the evidential requirements which form the basis, because again, the Scottish Government as a public authority in terms of the Human Rights Act has its corresponding, as does the court, obligation to ensure that there are in place in Scotland effective criminal sanctions. And if the situation was such that the balance, this delicate balance of rights, was adjusted in such a way as to render that impossible, then the government would in itself be failing in its positive obligations to ensure that those are...
But I mean, we can't assume that the present system is just. I mean, it may be a balance, but whether it's a correct balance now is the whole issue.
Well, that, my lord, is what this, of course, what this case is to determine, whether or not things have moved on, or whether or not Strasbourg has made a declaration which itself is innovative or legislative in its nature, as opposed to a natural evolutive development of jurisprudence which it has developed over the years, which seems to go in a direction which is quite distinct from the case of Saldus itself. And I will come to the pre-Saldus jurisprudence and that pattern, and why it does seem to be something which is unexpected and a turn which does not appear to follow
do you know, is there anything in the Strasbourg jurisprudence about the seriousness of the offence of which the suspect is liable to be accused? I haven't detected anything of that sort. And Section 14 applies if to any suspected of any offence punishable by imprisonment, without any regard to whether imprisonment is actually likely to follow.
Yes, it does.
So, which is borne out, I suppose, by the statistics you mentioned to us of the huge number of Section 14 detentions that there are.
Yes, not. I'm not aware, I have a recollection, my lord, without that where the more serious the crime, the greater the scrutiny there must be of what is said in terms of an admission, but not reference to the need or corresponding need for a solicitor in those contexts. But it is not the case in McLean, where the lordships have said that the absence of a solicitor will always somehow allow automatically the admission of what takes place.
End of paragraph 54 in the Saldus.
I'm obliged, my lord.
Yes, exactly.
I think at the end of that paragraph, my lord, I haven't it before me, but there's also reference that where there are restrictions, exception where there are restrictions, the timescale must be circumscribed. It's recognising that there may be exceptions.
I mean, I think in the case which eventually was decided about the right not to incriminate yourself in connection with road traffic offences. I can't remember which one it was. Well, not Brown and Stock, but the one which eventually was decided in Strasbourg.
Yes.
There, I think it was recognised that you could balance the thing and you could say, well, it's a relatively minor matter, and therefore the degree of self-incrimination, whatever it is. Is that correct?
Yes, my lord, yes. Yes.
Which case is that?
That was a case of Francis and O'Halloran against the United Kingdom.
O'Halloran.
Yes.
Sorry, you gave us the reference, I think, earlier, didn't you?
Where?
5/130.
5/130.
Yes. I referred to that case, my lord, earlier.
Yes.
Brown turn.
Of course, it was in this case that the court in Strasbourg revised its earlier position as it had reached in the case of Saunders, following the case of Brown against Stott. Strasbourg retreated to some extent, if I may characterise it in that way, recognising that that balance could be reached in circumstances.
Paragraph 57 of O'Halloran is really drawing on the point that people who drive motor cars around in the streets are under some kind of obligation to inform the authorities of the identity of the driver if there's a suspected offence. So it's a rather special feature, but it's related to the nature of the activity.
Yes, ma'am.
There's a rather splendid concurring opinion by Judge Borrego to that effect.
Yes. And yet, my lord,
Saying that's all they needed to say, actually.
Yes.
The rest is...
And yet the compulsion, the compulsion contained in section 172 can relate to very serious criminal charges. It may result in producing evidence for culpable homicide or for contravention of section 1.
This is also, sorry to interrupt you, also the case in which the dissenting judgment of the judge from Moldova attracted particularly sharp comment in a well-known lecture by Lord Hoffman, I think.
Yeah,
that's right.
Yes.
So it was the UK's fault for having such stupid laws.
We're also driving alongside the road.
Which bit is it?
It's page 438, 3334, I think.
Yes, wrong kind of legal solutions. Yes.
My lords, once the detention period is concluded, and although it's a maximum of 6 hours, it will be obvious from the appellant's case that it can be a relatively short period. I think it was 27 minutes he was interviewed in that period, a total period of 85 minutes. Once that period is complete, the accused must be arrested, and the full rights applying to an arrested person under Section 17 would apply. The right to have a solicitor at that stage advised and to be informed of his rights regarding that matter. Once an accused has been arrested, he will appear in a serious matter before the court on petition in Scotland, and at that stage, at that early stage, it will be open to an accused person to, if he wishes, make a declaration regarding any extrajudicial confession which has been attributed to him.
Is that right actually exercised from time to time?
It's not exercised commonly, but it has been exercised in 2 or 3 cases. Normally, the procedure would be to make no plea or declaration, and that is routinely the position. But on occasion, an accused, particularly if there was an accusation regarding the propriety of an extrajudicial confession, will take the opportunity to make a statement that that confession was obtained under duress or in circumstances which were improper. And it's another safeguard at an early stage before the court. Immediately after arrest, the first lawful day when they're brought before the court, the accused, with the attendance of the solicitor, has the opportunity to challenge the making of that statement. But contrast that, my lords, with the Turkish situation, which we've looked at in a series of cases of weeks and months, sometimes in custody, prior to attending before the court, with only the appearance before the investigating judge without the benefit of a solicitor.
Custody court in Glasgow would soon grind to a halt if people were regularly making declarations.
The occasions when it does grind to a halt in any event without that, my lord,
Absolutely.
which is
Pretty exotic thing if it ever comes up, a declaration. You have to look up the books to see it all as well and what you can do with it and all that stuff.
Yes, but it is something which solicitors would be aware of. And in the event of a serious challenge, it certainly is there. It's part of the armoury, my lord, that is available for the detainee to challenge that which may have been unfair, even if it's not exercised. And hopefully the reason it's not exercised, my lord, is because there is no duress or there is no ill treatment or indeed deception or impropriety during the course of such admissions because of the protections afforded during Section 14. There is also, of course, as part of the investigation itself, additional protections which the accused can deploy regarding any allegation of impropriety or defiance of his will in the making of any statement. The defence in Scotland have a right to precognize the police officers who are present when the statement is taken, and they may interview that individual about the nature of the statement and what information they had at that stage, and they indeed may challenge the police officer and assess the demeanour of the police officer themselves as to what took place. And if the witnesses refuse to do so, they have a right to have the individual brought before a court to be precognised on oath. So they don't simply have to rely on the police statement. If this is central to the case, if it's an important and significant part in a serious case, they have this right of recognition. It is open in the trial proceedings to the accused with legal assistance to challenge the admissibility of all or any part of anything said by him, and indeed very often there may be aspects of an admission under Section 14 which are edited out of the transcript, simply removed because of any suggestion that it might reveal, for instance, a previous conviction of the accused or previous bad character. And that is, again, a common feature of a transcript of an extrajudicial confession under Section 14 when lodged in the trial proceedings. That will take place in solemn matters, serious matters, as a preliminary matter before a preliminary hearing. At such a hearing, the onus is on the Crown to satisfy the court on the balance of probabilities that the statement was freely and voluntarily given and that it was not extracted by unfair or improper means. And again, it will be open at such a hearing for the accused to lead evidence bearing on whether the statement was freely and voluntarily given, including expert evidence in relation to any vulnerability by reason of age, medical or mental condition or otherwise of the accused. The accused himself may give evidence at such a hearing without being required to answer any question about the substance of the charges, thus protecting his right to silence. The decision on admissibility, my lords, is made by the judge following the hearing. If the objection is sustained, the evidence will not be led before the jury. That matter will be dealt with before the Crown case is closed, so that any no case to answer submission will proceed on the basis of the admissible evidence. At the conclusion of a Crown case, if such an admission is therefore excluded, it will not go before the jury for consideration. There is a procedure in Scotland where the defence may make a submission to say that there is an insufficiency of evidence to allow the trial to proceed to the jury for consideration. I'm not aware of such a procedure in England and Wales at the conclusion of the Crown case. So it's another way of knocking out.
Sure, certainly is.
At that stage, my lords?
Certainly.
Absolutely.
You'll not put your election.
I remain correct, my lords.
I think there was some concern when this was introduced that it was introducing English procedure.
In 1980 it was introduced, my lord, in Scotland.
It was in England long before that.
Yes. I thought it was at the conclusion of the defence case that such a submission would be making in England. Clearly I'm mistaken on that. The accused statement will be excluded if it is unfair or improper methods have been used by the police in the way the interview was conducted. The fact that clearly that the interviews are tape recorded facilitates close examination of such questioning. An accused's answers to the police will be excluded even where the means by which the interview was conducted were fair and proper, if the circumstances demonstrate that the suspect was at such a disadvantage. And my Lord Mance yesterday referred to the vulnerability or the nature of the relationship between the police and the suspect. But such evidence will be excluded if such a disadvantage by reason of age, physical or mental condition, or lack of competence in the understanding of English or otherwise, that he could not properly comprehend his situation or appreciate his right to silence, that the result was tantamount to denying him that basic right. And I'd refer there to the case of LB against Her Majesty's Advocate, which is cited at 2003 Justiciary Cases, 94, at Volume 2, tab 28. The more crucial the evidence may be to guilt, the more scrupulous must the court be in ensuring that it has been fairly adduced. And clearly the presence of a jury is another factor in terms of impartiality, and a further stage where even if the judge upholds the fairness of the admission and has no difficulty with it, it's still a matter for the jury to accord what weight they will to it. And they have the ability to listen to the tape or watch the video recording to determine the extent to which they feel the accused gave the evidence freely and voluntarily, understanding his rights, and to consider the quality of the police questioning, the demeanour, attitude or articulacy of the accused.
Is it worth looking at LB? I'm not familiar with the case myself, but it's an example, is it, of...
It's a 14-year-old who was questioned, and it's at Volume 2, tab
And this
28.
was an interview, was it, and while detained?
Yes, my lord.
Taken into custody, taken on detention at about 3 o'clock in the morning.
Yes.
And it's an example of what goes on, is it?
My lord, if it was an example of what was going on, there would be many more cases excluded on the basis of that. That where there is not an appropriate adult, or where the circumstances were such that took place, then the courts will clearly, as they did in this case, exclude that evidence as not being compatible with a fair trial.
And the issue was whether the appellant understood the caution. Is it as simple as that?
Yes, my lord, the abuse or indeed the improper behaviour has to be addressed as another protection. And there is, of course, disciplinary regulations. There is the role of the Procurator Fiscal investigating any improper behaviour on the part of police officers, so that if there was an attempt to pervert or there was improper behaviour towards an individual who was detained in any way, it would be subject to the criminal sanctions of the courts and the independent role of the Procurator Fiscal in that regard in investigating any such allegations. And as I mentioned, under terrorism provisions, the Sal Dues type of case would be subject to the Terrorism Act, and thereby there would be a right of access to a solicitor, recognising the complexity and indeed the length of such investigations and the longer period, the very substantially longer period that a detainee may be kept in custody during such an investigation in Scotland. Questions of compliance, if I'm moving on now to Article 6 and the right of access to a lawyer in Scotland, my Lord, of this procedure with Strasbourg jurisprudence has been examined by the Commission in the case of Windsor against United Kingdom and Robson against United Kingdom, which are both contained in Volume 6 at tab 159 and 140. It's where the particular provisions under Section 14 were examined by the Commission. And the factors referred to by the Commission in holding in both instances that there was not circumstances such as to result in unfair trials, contrary to Article 6 regarding Section 14, included in those cases the short period of duration of the detention, the fact that thereafter there was unrestricted access in preparation for and during the trial.
I'm not sure I got the references correctly. It was 159 was Windsor.
Windsor against the United Kingdom,
Yes.
at volume 6, tab 159, my lord,
And the other one?
and is at volume 6, tab 140.
Thank you. Here he is.
The short duration of the period, the fact that thereafter there was unrestricted access in preparation for and during the trial, the accused's attitude at trial, whether any objection to admission and evidence of the interview was made, the role of the judge's charge as a safeguard, and the independence and impartiality of the jury were all looked at by the Commission in the context of Section 14. Further, in the case of Payton against Ritchie, very shortly after the incorporation of the Human Rights Act and the Scotland Act, its passage.
Which pages in the one you were referring to are the most helpful?
These, that's a summary, my lord, but in the interest of progress, simply summarise
we have to read it.
It's quite important to see. I mean, I'm
Yes,
not very
certainly, my
familiar
lord.
with these cases. So which should we start with? I think we should look at
We
Windsor
should start,
first.
my lord, I think, with Windsor against the United Kingdom.
Yes.
At dated the 14th of December 1988, 159.
Paragraph 2 on page 3, he complains of being refused access to a solicitor for 6 hours. That's under the old article, the old section 2.
It's page 4, about 3/4 of the way down, which looks a little strange nowadays. The Commission first observes that the Convention does not expressly guarantee the right of an accused to freely communicate with his defence counsel, i.e. his solicitor, I suppose, for the preparation of his defence, and so on.
It may not be.
Can't be said to be insusceptible of restriction, and so on.
The right for an accused to communicate with the law has been recognised.
And at the foot of the page, he's not established that the initial period of 6 hours was of crucial relevance to the presentation of his defence.
Yes, well, the assertion in the third paragraph about the absence of express right is repeated in later cases. Indeed, just 2 weeks before the case of Saldus and the case of Ivanenko against Russia, the court referred to the mere absence of a solicitor, not amounting to something which in itself would necessarily breach Article 6. And I will come to that case at a later stage. Just 2 weeks before the court itself took a quite apparently significant different emphasis regarding that matter. The right to communicate with the solicitor is part of the guarantees in Article 6. How a state affords that, the mechanism by which it's afforded, will vary from one state to the next and is not dictated by Article 6.
Or did Mr. Windsor make a confession within the 6 hours that he was unadvised? If he did, it might help. If he didn't, I don't see how it can.
Wallace suggests in the final paragraph, page 4, that he can't have done.
No, the present case, the applicant had the possibility of over 3 months. The applicant had not established the initial period was of crucial relevance.
Well, it's the part which says that the applicant has not established that the initial period of 6 hours was of crucial relevance.
What seems to have happened on page 1, that during that time he was questioned, subjected to forensic tests and shown to 2 potential witnesses.
Yes. Neither of whom identified. After approximately 6 hours, the applicant was charged. He first saw his solicitor. So there's no suggestion of an admission arising from the circumstances of Windsor.
I mean, I think it's, I was speaking entirely for myself, I mean, it's self-incrimination, it seems to me, at the guts of this particular case.
Where was the other case, Lord?
And yet, in the case of Robson, my lord, is the subsequent case in 1996.
Which tab was that?
It's at tab 140.
Yes, there was reliance there on statements made during his questioning.
Where's this?
There was a challenge to the fairness of the statements made by the appellant in the context of a drugs charge and 2 charges of reset.
So this is an admissibility decision on what of relevance is declared inadmissible, the Article 6.3c point.
Yes, my lord.
On what of relevance?
The applicant was represented at his trial that the short period or the short duration of the period of detention prior to access and the fact that thereafter there was unrestricted access in preparation for and during the trial itself. References also made during the course of both these to the role of the judge and the
Well, I think the important paragraph is the third paragraph on page 2.
Yes, my lord. Beginning with in an appeal.
So during the trial, the prosecution relied on certain statements made by the applicant during his questioning by police.
And the critical finding, the conclusions are helpful to you on page 7, aren't they? The third, fourth and fifth paragraphs. It was very short and there was deprivation of access to a solicitor. Didn't mean there wasn't a general fairness and so on.
No objection taken at the trial.
Yes.
Formal objection against the admissibility. But it does look, as Lord Roger was saying, very old in comparison with what we now see in Salvador.
Yes, it is 1996, but my lord, while it's old, what I hope to show or demonstrate, my lords, is that in fact that many of the later cases, right up until Saldu's, deal with similar situations and do not come to the conclusion that there was a breach of Article 6. And that there is indeed something of a departure in Saldu's from what appeared to have been the norm up until that point.
It says there that he was questioned by the police and the Commission finds the applicant was informed of his right to have a solicitor present. He's got no such right.
I think in the case of Robson, he had been detained for 6 hours and arrested for a period of 2 hours thereafter.
Oh, I'm sorry, now I'm getting lost.
During the period of 6 hours, he'd been, clearly there had been no access to the solicitor.
So is this the 6 hours before the 7034 on the 4th of April, was it?
It must be, my lord, yes.
No.
It doesn't look like it. I mean, if you look at page 1, it looks as though...
He was informed of his right to have a solicitor present, which is nonsense.
70. He was informed of his right to have that
They've misunderstood the position.
arrest rights of accused. Well, it might be.
Is that right? I mean, was it after he refused this during questioning? And they've been using the form. They've been using a form which seems to be an arresting form. I mean, detention, a person who's been, if he was detained, he was detained.
Well, it's a different form altogether, my lord, for detention.
Yes, I know.
But again, there would be no questioning which would be permitted. The trial would simply not have taken place on the basis of any admission which took place following arrest.
Well, in that case, he had no... They are mistaking the situation because they're proceeding on the basis that he was told of a right to have a solicitor present when there is no such right.
I think, my lord, that if you look at the period which they relate to is a period of 8 hours. If that's...
Well, the note of page 1 noted the applicant was informed of his right to have his solicitor present at 7:34. Handwriting of the form rights. 1550 of the same day was again noted. Could not be contacted. So
2, 3. So, yes. Listed during the time. Yes, the applicant complains about his treatment by the police while he was questioned by them and that he was refused a solicitor during that time.
Yes. And then they go on to say that he was informed of his right to a solicitor, which is completely wrong. He had no such right.
The key point appears to be at the foot of page 6, my lord.
Sorry? Page?
The applicant also... Sorry, my lord?
Page?
Page 6, my lord.
Yeah.
The applicant also complains about his being refused a solicitor when he was questioned by the police. As regards the applicant's allegations about his treatment by the police when questioned, the Commission notes the following. The applicant's counsel did raise such issues before the jury during his trial as a basis for challenging the evidentiary value of statements made by the applicant during questioning by the police.
Well, there are 2 points. First is, in the first place, he complains about his treatment. The second, he says, being refused a solicitor. They deal with the complaint about the way he was treated in the paragraphs beginning as regards, and in addition, accordingly. And then they go on to say, as the applicant's complaints about a refusal of access. They deal with it there. And then they begin off by saying he was told of his right to have a solicitor present. Well, if he was told that, he was told something which was untrue.
Except, my lord, as I understand it, that refers to his change of status when he was arrested.
I'm not sure about that. It's not at all clear from the narrative.
We obtained the Robson papers from the archives because of the apparent confusion which there was apparent in this. And the understanding of the papers was that, and I'll be corrected by my learned colleague, it was that it was quite clear that there was 2 separate periods of 6 hours and 2 hours in the period, which, if clearly the questioning had taken place post-arrest, it would not have been admissible. There would be no question of that being the case. It has to relate to the period of detention.
At which point there was no such right of access to a solicitor.
Trapped either way.
Yes, absolutely. Useless case.
Yes, my lord. The facts of the case, as I understand it, are complicated. What I might try to do this evening is to have a look at the papers of him.
Did this case go through the appeal court? It presumably did at some point, otherwise it wouldn't have got to Strasbourg.
In terms of exhaustion of remedies.
Yes.
Yes, but I mean, it presumably was taken to Strasbourg after the appeal had been refused by the appeal court in Edinburgh.
Yes.
And was it a reported decision?
I don't know.
Doesn't look like it.
Sorry,
I'm advised that it's not reported.
Well, it does look as either
Presented
way.
his appeal in person. One of these ones, page 3. Paragraph E on the 6th of January.
Yes, so it doesn't sound as the sort of thing that would have been reported.
He abandoned his appeal against conviction.
Yes.
He wished to maintain his appeal against sentence.
Yes.
So he abandoned his appeal against conviction.
Yes, so it never got to any reasoned decision.
Yes.
Well, time is running out as far as today is concerned, Lord Advocate. Where do we stand then as far as today's submissions are concerned?
My lord, this is to finish at 4 o'clock.
Yeah.
At this stage, my lord, I would just simply wish to conclude this portion on salaries in Article 6 and move on to look at the relationship between Article 6.1 and 6.3c briefly tomorrow morning. The pre-Saldus case law, Saldus itself clearly, and the post-Saldus case law before examining the appellant's case, which was not referred to in any level of detail yesterday, but which I think is important to look at what took place in the appellant's case, and thereafter to move on to the ESTO position regarding Section 2 and of the Human Rights Act, as well as the other.
Well, might I suggest it's quite important. Let's assume, and this you mustn't assume that we've formed any view yet, but let's assume we are against you on this issue. Then there is a very important point as to what we do about the decision in this case, and I'm assuming also we're against you on Section 2,
Yes.
if we get to the point of whether the decision should be retrospective or not, there are various possibilities, I suppose. One could be that one would have to allow this appeal, but as far as the rest of the system is concerned, give you time to put the legislation in place for the future. And meantime, cases are not subject to this decision. It's a very difficult point to reach, but there are a variety of solutions which might assist your position, and I think we would be assisted by.
Yes. I would also hope to address the court, my lord, on section 57.3
Yes.
regarding that, prior to that position being
Certainly.
obtained, regarding giving effect to provisions in terms of a UK
Yes.
statute.
But we may reach the position that we're against you on every point, and it's a question really of what the solution is to avoid a complete collapse of the system.
Yes,
And all the cases that lie in the past. I mean, it's an appalling prospect, but
yes.
we may find we have no alternative but to face up to that. And the question is what solutions you have to offer at that stage. Well, we'll see you again at 10 o'clock tomorrow.
Certainly, Lord.